and you did nothing. Let me ask you this. Do you not take this seriously at all?
I do take it serious. Yeah, I'm busy. I'm a very busy person. It's kind of inconvenient for me.
This is all inconvenient. She's too busy and it's inconvenient. Really, this isn't all about you. You made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident.
This woman walked into court like the rules don't apply to her, and it's unbelievable to watch. She's already racked up more than 15 violations, and now she's standing there telling the judge that the court's conditions are just too inconvenient. That's not just a weak excuse, it's practically announcing that she doesn't take any of this seriously. Her original charge was drunk driving, already reckless and dangerous enough. But instead of showing remorse or compliance, she's treating court orders like they're optional chores. Judge Simpson isn't buying it for a second, and honestly, jail time is starting to look like the only option left on the table. The entitlement on display here makes this one of the most outrageous courtroom performances I've ever seen. But the big question is, do you think she even realizes how bad she looks right now? Let's dive in and watch.
The bond violation, or sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Ms. Wilson, is that on the 17th, you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty flow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I stop? Yeah. I worked both.
What'd you say?
I work Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad, or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. during the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Yeah, because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me
That's
of that.
sure.
She did inform me of that yesterday when she tried to test on the sober link on the 18th. It gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there, I can't.
But you did nothing. And then, let me ask you this. Do you not take this seriously at all?
I do take it serious. Yeah, I'm busy. I'm a very busy person,
Okay,
and that's not an excuse,
we all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient.
The moment she told the judge she was too busy to set up her tether, the entire hearing shifted. To a judge, that isn't just an excuse, it's a straight-up signal of disrespect for their order. Court isn't a suggestion box, and when you admit you can't be bothered, you're basically daring the judge to punish you. Sure, nobody wants a tether. It's awkward, restrictive, and embarrassing. But acting like you're above it all only makes things worse. Judges hear excuses all day long, and when one comes off this entitled, it kills any sympathy instantly. The irony is that a tether is one of the lightest consequences she could have faced, yet now, she's making jail look like the better option. Legally, bond conditions aren't optional. If you ignore them, the judge can pull your bond altogether. And the way she said it, with confidence, like the judge would just nod along, was almost unbelievable. Judge Simpson's reaction said it all. Did she really just say that to me? Painful to watch, but fascinating at the same time.
It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her,